Hi, and welcome back to Chapter 8 in your commercial law curriculum. This week we're going to be talking about the last element in our common law analysis of contracts, and that's the proper form of the contract when it's required to be in writing. So far we've gone over the common law requirements of offer and acceptance, consideration, mutual assent of the parties, capacity to contract, legality in contracts, and again, this week we're going to go over when a writing is required, which can be a common law element in some contracts. After finishing this chapter, I'd like you to be able to understand the Statute of Frauds, list the types of contracts required to be in writing under the Statute of Frauds, recognize the rules of contract interpretation, define the parole evidence rule, and distinguish between an integrated contract and a partially integrated contract. So this chapter sets the stage for what could be the last requirement in our analysis as to whether or not a contract is enforceable, and that is simply whether or not the contract is required to be in writing. Complying with all the other elements that we've talked about so far may not be sufficient in some cases, because in some cases the law requires a contract to be in writing to be enforceable. The statute that sets out this requirement is called the Statute of Frauds. In the 17th century, Parliament recognized that the courts were having a lot of problems enforcing oral contracts, and so they brought about this rule that certain types of contracts had to be in writing. That rule crossed the Atlantic with the Founding Fathers and has become a part of our contract law. And virtually all states except Louisiana have adopted some form of this statute. And so it has become the basis for challenging the enforceability of contract across our nation. And the bottom line is that if a contract fits within the confines of the Statute of Frauds, even if you have all of the other elements of the contract present, it may not be enforceable unless it's in writing. In other words, it has to be in writing to be a valid contract. So remember that not all contracts have to be in writing to be valid. Oral contracts in some cases are valid and enforceable. It has to fall under the scope of the Statute of Frauds in order to require a writing. So what kind of contracts do require a writing under the Statute of Frauds? Well, any contract that by its terms cannot be performed within 1 year of making, any contract to answer for someone else's debt, when dealing with estate law, an executor's promise to pay the estate's debts, any contract dealing with marriage, and any contract involving real property. So let's take a look at each one of those. Now, the first of the 5 types of contracts required to be in writing seems like it's simple on its face, but let's take a closer look. The first thing I want you to key in on is the fact that it has to be performed within 1 year of the making. So let's say that you sign a contract on August 15th of this year, and that the contract requires performance between September 1st and August 31st. So you sign it on August 15th, you don't begin until September 1st. Even though your contract is for only a year, September 1st through August 31st, you signed it on the 15th, so it's going to take a year and 15 or 16 days to perform that contract, so it's more than a year. Even though the contract's for a year, the time of the making is what we're looking at here. The second question is you have to decide whether or not it's possible for performance to occur within 1 year. Is it possible, in other words? So one example where we have some problems with this are lifetime contracts. Most of us think of lifetime contracts that are hopefully going to be for more than a year. But is it possible that we could die within the year? If the answer is yes, then there may be a different interpretation available. Because since the possibility exists that we could die within 1 year, that means it's possible that performance could occur and be completed within 1 year. Your lifetime's less than a year. And therefore, it's not required to be in writing. So in our first instance, a writing would be required because performance could not happen within the year of the making of the contract. In the second instance, lifetime contract, where it looks like it's going to be definitely more than a year, it's possible for that performance to be less than a year, and therefore some courts are going to say that a contract is not required. So first look at the date of the making of the contract. Next, ask yourself, is it possible that the performance could occur within 1 year? The next type of contract that's required to be in writing is a contract to answer for another person's debt. You know, in most contractual arrangements, we're talking about two parties being involved, the promisor and the promisee, and each has an exchange of obligations there. But when we talk about a third-party contract where two people are involved in the contract itself, but one of the parties is promising to do something for a third party that's not involved in the contract, then we're going to require a writing. You think about this. If you're required to pay for the debts of a third person, you want to know about that, right? So the courts are not going to allow the two parties who are involved in the transaction to say a third party is liable for the payments in that transaction unless the third party knows about it, thus the requirement for a writing. Take, for instance, a situation where a friend of yours goes to buy a car. So you have the seller of the car and your friend, the buyer of the car. The two of them get together, and the buyer of the car says, hey, my friend is going to pay for this car. Well, you don't even know about it, so you wouldn't be required to pay for it under the law. However, if you're there, that contract is in writing, and you sign it, then you are liable to pay for the debts of that third party. But critical to this analysis is the knowledge of the obligor, the person that has to pay the contract. Now change this situation just a little bit, and let's say you take your son or daughter in to buy a car, and you ask the person selling the car, if you sell this car to my son or daughter, I will pay for it. In that case, you're there, you know about it, and there's actually some benefit to you as the parent because it's your family member that's getting the car. In that case, we're probably not going to require writing because you have both knowledge of the contract itself and your obligation to pay for it, and there's also what we call the main purpose rule. That third party, you as the obligor, are actually benefit from the promise which was made directly to the seller themselves. So in that case, no writing would be required. The next type of contract required to be in writing are contracts that deal with executors of estates. And when we deal with probating of wills, it's common for a personal representative to be appointed to administer the interest of the deceased party, to administer the estate, allow for the orderly unwinding and distribution of assets of the estate, including paying off debts. Now, the estate itself, the property and the cash and so on that's left over from the decedent, is normally required to pay the debts of the estate. Nobody else is required to pay those debts. So if that personal representative, the executor, is somehow required to pay the debts of the estate, we're going to require that to be in writing. The next contract required to be in writing may surprise you a little bit. It's contracts in consideration of marriage, and it's actually based again on Old English law where dowry rights were very important, where people married more for position or status than they did for love. So the original purpose of this portion of the Statute of Frauds was to make sure that if there was a contract for marriage, it would be in writing. You couldn't promise things. I'll pay you if you marry my daughter, I'll pay your family if you marry my daughter. Couldn't be oral, it had to be in writing. The most common present day use of this section of the statute in frauds involves something we're probably a little bit more familiar with, and that's premarital agreements, prenuptial, antenuptial agreements that now must be in writing. In other words, you can't have an oral prenuptial agreement. Those types of things have to be in writing. A prenuptial agreement would be something that the husband and wife agree to before the marriage that decides what will happen if the marriage doesn't work out. Perhaps the most significant area of the law that deals with the statute of frauds is real property. Virtually any agreement that involves real estate must be in writing. Things like deeds, mortgages, deeds of trust, leases, easements. Again, virtually anything that deals with real property in any way must be in writing to be enforceable. As with most rules, there is an exception that applies to the requirement for writing, and that is the doctrine of detrimental reliance. This is an exception in equity to the writing requirement. And essentially, what we're looking at here is a situation where, let's say, an individual promises to sell real estate to someone, and the purchaser moves on to the real estate, pays part of the purchase price, takes possession of the land, makes improvements to it, In that case, a writing may not be necessary because some of the performance has already happened, and the purchaser has detrimentally relied on the seller's promise to sell the property. So the seller can't come back later on after the improvements have been made, after the buyer has moved in and things like that, and say, hey, we didn't have a writing. Now, some states have additional types of contracts that must be in writing. Very common is that the appointment of an agent to perform duties must be in writing. In other words, if I ask someone to go and sign a document for me, that document is not going to be enforceable unless there's an agreement between myself and the agent giving them the authority to sign on my behalf. And this next one actually comes from the Uniform Commercial Code and is sort of a crossover between common law and the UCC. And the UCC requires that any sale of goods over and above $500 is required to be in writing, must be in writing to comply with the Statute of Frauds. Okay, so now that we understand what types of contracts must be in writing, how do we satisfy the requirement for a writing? And it's really fairly easy. It's just a few minimal things that have to be included in the written contract. First of all, we're going to need the identity of the parties. Anybody that's going to be bound in writing must be identified in the contract. Next, the subject matter of the agreement. We don't want to have any questions between the parties as to what the subject matter is, so it has to be clearly noted to satisfy the Statute of Frauds. Any material terms or terms that are material to the performance of the contract, like price or the consideration that we talked about, are going to have to be in there. And then any parties that are going to be charged with performance under the contract have to actually sign the writing itself. Again, with any rule, there are usually exceptions. There are 3 equitable remedies or exceptions to the Statute of Frauds writing requirement. We'll talk a little bit about this with regards to real estate. They're part performance, promissory estoppel or reliance, and equitable estoppel. So in the case of part performance, let's look at an example. Let's say a buyer and a seller get together for the sale of a car, and they decide that the purchase price is going to be $1,200, payable $100 a month for the next year. Since it's for the sale of goods over $500, we know that that contract is required to be in writing, but the parties don't know that, so they fail to make a writing. The contract goes on for 6 months. The buyer religiously makes those payments of $100 a month, and in the 7th month the seller comes back and says, hey, this contract was required to be in writing, I want my car back because we didn't satisfy the Statute of Frauds. In this case, the buyer would be able to use the equitable remedy of part performance. In other words, they're halfway through this contract, I've performed my duties under this contract, and we're not going to allow the seller to cancel the contract because of this part performance doctrine. The doctrines of promissory and equitable estoppel deal with something that one of the parties said, did, or failed to do. And what we're looking here is, what the court's looking to do is prevent some type of unjust enrichment. So let's look at the same example. Let's say that buyer and seller get together and they're going to sell that same car for $1,200 payable over 12 months. They make the oral contract, and at the same time, the seller has some parts for that car that they also want to sell along with the transaction. So the buyer pays $250 upfront for those parts. Those parts only fit the car that's going to be bought. So the seller now has some money. The seller comes back then and says, you know what, this is required to be in writing. I no longer want to sell the car. Well, the buyer has already paid $250 for the parts for those car, and the seller won't take them back in this case. And so the seller would be unjustly enriched because the buyer can't use those parts. So in that case, the courts may waive the Statute of Frauds or waive the writing requirement of the Statute of Frauds and force the seller to go through with the transaction. Equitable estoppel is similar, although it deals with one party indicating to the other that a writing is not required. So same situation, parties get together, buy that $1,200 car, and the seller themselves says, I know for a fact that a writing is not required. Obviously, we know that that's not true because the sale of goods over $500 requires it. The buyer detrimentally relies on that misrepresentation, and therefore we're not going to require a writing. So that's equitable estoppel. And these are 3 remedies or exceptions to the statute of frauds. Exhibit 8-5 in your book is a great chart to take a look at if you're trying to understand the exceptions to the statute of frauds. When a court takes a look at a contract, they're looking at words on a piece of paper, but sometimes it's hard to ascertain what the parties meant by the language they put in there because words have different meanings to different people. So the courts need some tools to interpret the words on the page, if you will. We're going to talk about 6 different ways that the courts do that. First is what's called the strict construction doctrine. Strict construction is when the courts only look at what's in the document itself. They're not going to accept outside evidence to prove what's in there. And when they do that, sometimes they use what's called plain meaning. Instead of looking to what the parties thought words might mean, they're going to give words in the documents or the documents themselves generally accepted meanings for those words. There's also, if there's conflicts between words or clauses in a contract, they're going to take a look at the difference between what we call boilerplate and negotiated terms. Boilerplate would be standard clauses that you see in most contracts. Negotiated terms are things that the parties specifically talked about, maybe changed the wording of, and they've really thought about and taken a look at it. So if a negotiated term or a negotiated clause is different from a boilerplate, one that the parties didn't look at, then negotiated term is going to supersede any standardized boilerplate term. The courts will also look at businesses in general and the parties themselves and how they traditionally act with regards to each other. And we look at custom and usage, course of dealing, and course of performance. Custom and usage is how does this business community generally deal with these types of contract? What would be normal business practices? Course of dealing is you, instead of looking at the business environment as a whole, you're going to look particularly at the 2 parties to the contract in this particular setting. And course of performance is actually the 2 parties, what they've done in the past. It also can make a difference as to whether or not a contract has been fully performed. A contract that is signed and is finalized but hasn't been fully performed is called a partially integrated contract. In this case, the court may allow some oral evidence to help them determine the purposes of the contract, terms in the contract. If, however, the contract is final and complete, it's called an integrated contract, and in that case, the court will not allow any oral evidence. Finally, we want to look at the parole evidence rule. Parole means oral or verbal. The parole evidence rule basically states that a written contract may not be varied, contradicted, or altered by any prior or any contemporaneous oral declarations. Once a contract has been reduced to writing, that's the final expression of the parties' agreement. It can't be changed or challenged by any parole or oral evidence. This rule prevents parties from changing their agreement after the contract has been written, signed, finalized. So oral evidence can't be used in most cases to change a contract, but there are exceptions where the court will allow oral evidence to come in order to supplement a party's intentions and try to determine what the party's intentions were, explain or clarify a contract, ambiguous language, show that conditions precedent, conditions that had to be satisfied prior to obligations arising, were unmet, and to raise defenses to the formation of the contract itself. So, to sum up what we've talked about here today, the Statute of Frauds dates back to English common law and requires that certain types of contracts must be in writing to be enforceable. There are 5 types of contracts that must be in writing. They are contracts that cannot be performed within 1 year after making, contracts of a third party to pay the debt of another, contracts made by an executor or an administrator of an estate to pay the debts of the decedent's estate, contracts in consideration of marriage, and contracts for the transfer of real property. The Statute of Frauds has certain minimum requirements for the writing itself. We have to show the identity of the parties, the subject matter of the contract, the material terms, the price, and it has to have the signature of the parties that are going to be bound by the contract. When a court looks to interpret a writing, it's going to look to both the words and the intentions of the parties. One of the rules of construction the court will use is strict construction, or the four corners doctrine. The court will also tend to give words their plain meaning and consider general usage and general custom in interpreting the contract. The most important rule for contract interpretation is the parole evidence rule, which states that oral evidence cannot be used to modify or alter a written contract. There are a number of exceptions to the application of parole evidence, that oral evidence can be used to clarify but not vary a contract. It can be used when there's an ambiguity, a condition precedent, or destruction of mutual assent. In other words, a defense to the formation of a contract. So that's all we have for this week. As always, if you have any questions, don't hesitate to contact me. Take care.